I'm just going to say test and hope that someone can hear me.
I can hear you.
Great. There you are. Hi.
Hey, good afternoon. How you doing, Commissioner Baker?
Good. It's good to see you. How are you?
I'm doing well.
I can hear my reverberation in the hearing room. I'm sorry to say. Maybe that'll be a reason to talk very little.
All right. Well, good afternoon, everyone. Today is April 13th, 2021, and this is our Law and Policy Committee meeting. So, Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. All right. Let's go ahead and move to item number 1. This is public comment for items not on today's agenda. Do you have any public comment on the telephone or digitally? Hearing and seeing none, we'll proceed to item number 2. This is approval of the March 15th, 2021 committee meeting minutes. Commissioner Baker, do you have any edits or comments on the meeting minutes?
I do not. I didn't attend it, but I did watch it since this is my first meeting of this committee. So I'd be happy to move their approval.
All right, and I will second. Ms. Linker?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Excellent. All right, so the next item up is our legislative update. Before we move into the legislative update, though, just as a matter of scheduling, I apologize, I do have a hard stop at 3 o'clock. So if possible, if we can finish up legislative update no later than 2:15, I think that'll give us 45 good minutes to talk about item number 4, which is also of importance and interest to us. So, all right, let's go ahead and proceed to item number 3 then. That is our legislative update, and welcome Ms. Nakano.
Thank you, Mr. Chair, and welcome Commissioner Baker to Law and Policy.
Thank you.
I have a few updates on the status of Fppc sponsored and supported bills, and then also a few questions about potentially taking a position on a few other commission-related bills. So first, the updates. SB 686, a commission-sponsored bill by Senator Glazer relating to LLC disclosure, was heard in the Senate Elections Committee yesterday. The bill passed out of committee 4-1 with Senator Nielsen voting no. The bill has support from the League of Women Voters of California, and the California Chamber of Commerce submitted a letter in opposition. Important to note, in response to Cal Chamber's opposition, the goal of SB 686 and AB 236, the identical bill on the Assembly side, is to shed light on the true source of funds used by LLCs in elections in the state. The regulations, on the other hand, which the bills also codify, only get at the responsible officer. And this disclosure does not tell the public anything about where those contributions or expenditures came from or specifically what individual or individuals were the source of those funds. So to be clear, the goals of the bills are separate and different from the goals of the new regulations. The regulations became effective at the end of August last year, and the Commission has received about 15 questions about those regulations. They were pretty basic questions about compliance. There have been no advice letters or indication that there is any difficulty with compliance with the regs. The next bill, AB 236 by Assemblymember Berman. It's also a Commission-sponsored bill relating to LLC disclosure, and as I mentioned, it's currently identical to SB 686. That bill will be heard in committee this Thursday, the 15th. AB 1367 by Assemblymember Lowe, another Commission-sponsored bill, is also being heard in committee on Thursday, the 15th. Per the author's office, the bill will be amended to remove the one bank account provisions and to retain only the increased penalties for egregious personal use of campaign funds. There were some questions and concerns from stakeholders, and if staff is able to resolve those concerns, the one bank account provisions may be added back into the bill at a later time. Now I'm moving on to other Commission-related bills.
So before you do that, Ms. Nakano, thank you. Commissioner Baker, did you have any questions or comments for Ms. Nakano just on the committee hearing updates on our priority bills?
Well, thank you. And I do actually, can you say just a little bit briefly what the concerns were regarding the single bank account rule? And is there a possibility that it could be added in this legislative cycle if those are resolved, as opposed to next year?
We're still getting detail on exactly what those concerns are. The stakeholders have spoken with the author's office as well as committee consultants. I haven't spoken directly with them yet, but the concerns were enough where the author's office thought that it should be taken out at this point. So we'll be exploring that further, and I can share more information as I have it.
I also want to thank you for the outreach. I think it was at my urging that the FPPC team reach out to entities with respect to the Berman and Glazer bills and LLC disclosure to get their particular input, including the chamber. And I appreciate you doing that. Of course, we got their input, but it was at our, I think, really persistent urging. So I appreciate the outreach that we've done so we can be informed about the effects of those bills. That's all.
Thank you. All right, Ms. Nakano, please proceed.
Thank you. Okay, I'll start with AB 1590. This was introduced on March 18th. It's a bill by the Assembly Elections Committee and is an Omnibus Political Reform Act bill. The bill currently contains two sections, one of which makes a non-substantive correction to existing law, and the second which would transfer the duty to collect the penalty for failure to pay the annual committee fee from the FPPC to the SOS, which is currently responsible for collecting the original fee. The FPPC, under this proposal, would no longer be involved in enforcement of this provision. The section was included in this bill at the request of Commission staff, and the Commission late last year voted to pursue this proposal and directed staff to do that. Staff recommends that the Commission adopt a support position for AB 1590 for those reasons. The next bill is AB 319 by Assemblymember Valadares. That bill would prohibit a foreign government or principal from making contributions, expenditures, or independent expenditures in connection with the election of a candidate to state or local office, and it would prohibit the solicitation or acceptance of those contributions. Existing state law currently prohibits these foreign contributions and expenditures if they are made in connection with a state or local ballot measure. The prohibition added by this bill currently exists at the federal level. Federal law prohibits foreign nationals from making and persons from soliciting or accepting contributions to federal, state, or local elections. Federal law applies to foreign nationals, and state law applies to foreign governments or principals. Under the definitions for those terms, this means that state law does not apply to individuals who are legally present in the U.S. According to the author's office, AB 319 is needed because the FEC is extremely backlogged and deadlocked and is not enforcing the federal prohibition. AB 319 would allow the FPPC to enforce the prohibition even if the FEC does not. Relevant to note, the proposal originated with the Commission's Enforcement Division in 2016 and has appeared in former legislation, including in AB 2250 in 2016, which the Commission supported at that time. AB 319 has support from Common Cause as well as the Election Integrity Project of California. And Assembly Member Valadares' staff has reached out and asked whether the Commission would also support this bill. The next bill is SB 459 by Senator Allen. This bill can be separated into two main categories: lobbyist reports and lobbying advertisements. There are three main elements to the lobbyist reports section. First, the bill adds to what must be reported by lobbying firms and lobbyist employers. Specifically, it would require reports to include the name or number of each bill or administrative action lobbied for each client, and the client position that was publicly communicated. Second, the bill increases the frequency of reporting from quarterly to monthly for lobbying firms or lobbyist employers that meet certain monetary thresholds. Third, the bill requires an additional report during the 60 days before the legislative deadline to pass bills. Lobbyist employers would be required to file a report within 72 hours of retaining a lobbying firm to influence legislative or administrative action. This report would include the amount paid or that will be paid for the lobbying activity. The second part of the bill has a few additional components. This is the lobbying advertisement portion of the bill. The bill would require lobbyist employers to file an additional report following a calendar quarter in which they spend $5,000 or more on issue lobbying advertisements. The bill defines issue lobbying advertisement for these purposes to mean a communication that refers to a pending legislative or administrative action and that essentially urges a particular result with regard to that action. So for example, this could include an ad that says, SB XYZ is bad, tell Senator Smith to vote no on SB XYZ. That's an example. The bill would also require the advertisement to include a disclosure that states the lobbyist employer who paid for the ad. And the bill would require a copy of the ad to be provided to the official who was identified in the ad. All of the provisions in this bill would take effect January 1st, 2023, so there's a delayed operative date of 1 year past the default operative date. I'm bringing up this bill today because Commission staff has been communicating with the author's office on this bill and the Commission's related proposal relating to lobbyist audits and reports. One of the elements of the Commission's proposal was to increase reporting for all lobbyist employers and lobbying firms to monthly instead of quarterly in the third calendar quarter only. The purpose of this change would be to allow the public and others to see what lobbying activity has occurred at the end of each legislative year before final voting on most bills. The author's office has asked if the Commission would support the bill if they added monthly reporting in the third quarter. So the author's office is asking essentially if the Commission would take a support if amended position. The last bill I'll be discussing today is AB 975 by Assemblymember Luz Rivas. This bill does two things. First, it requires electronic filing of statements of economic interests for those for whom the Commission is the filing officer. And second, relating to gifts, the bill extends the time to make reimbursement for admission to an invitation-only event from 30 days from the end of the calendar quarter to 30 days from the date of the attended event. The first piece on e-filing is something the Commission is pursuing this year. Commission staff have recommended amendments to the bill for that section, technical amendments, but the author's office hasn't indicated yet whether they will take those amendments. The Commission's proposal also included capping the gifts limit at $500 to make it even with the earned income threshold for conflicts, but the author's office has indicated that they are not interested in including that provision in this bill. I won't be asking for a position on this bill at this time, but I wanted to bring it to the committee's attention since the bill does include a piece that the Commission has been supportive of. And I'd be happy to take any questions.
Thank you, Ms. Takana. Commissioner Baker, it appears that there are three bills that we are being asked in Ms. Nakano's report to potentially recommend a position to the full commission later this week. So my thought was perhaps we can discuss and take public comment on each of those and discuss them each separately, if that works for you.
That does. Sounds good.
All right. We'll start then with AB 1519. So staff is recommending a support position, and this is the transfer of committee annual fee penalty collection duty from FPPC to SOS. So Commissioner Baker?
Yes,
Comments?
I do think, and first of all, I want to say thank you again. I had reached out to Ms. Nakano in advance of today's meeting with a lot of requests for information about the bills, and she was very timely in response and thorough and succinct and organized. So I appreciate that. And I want to give a shout out as to thank you. I think for this particular one, it is appropriate for us to support this legislation. We've talked about it in the past, and we have a member who is interested in providing that vehicle. So I would be inclined to support the legislation for sure.
Great, thank you. I agree. This is something that the commission put out there that we identified as an area that we were hopeful that we could get legislative movement on. It sounds like that's coming to fruition. So I agree that we would want to support this as well. I do want to take a moment though and ask if there's any public comment just on AB 1519. We'll take up the other bills next, but at this time, do we have any public comment on AB 1519? 1590, that is correct, not 1519, 1590.
Okay.
All right, hearing and seeing none. Based on what Commissioner Baker said, I would then make a motion that this committee recommend to the full commission a support position on Assembly Bill 1590.
I would second that.
Ms. Linker?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. All right, moving next to AB 319. This is the prohibition on foreign government principals from making contributions, expenditures in connection with state and local elections, candidate elections. Commissioner Baker, thoughts?
Yes, thank you. And first, I would just disclose a very, very brief ex parte communication I had with staff of the member who's the author of this bill to inquire about the bill, both before it had narrowed its, I think it was before it had narrowed its scope. Originally, there was another provision in here, if I remember correctly, and I was inquiring about the bill. I would like to see us write a letter of support for this. It sounds like it has a history with us as something we've supported in the past. I do think substantively it is good legislation. I know that it does not include foreign nationals, and some may describe that as a loophole that would allow someone to get around it. But I think the backlog at the federal level, the deadlock at the federal level, and also just as a substantive matter, I think it is good for us to do. And I'd also add, I was struck that the groups that have written in support, Common Cause and the Election Integrity Project of California, some may not agree with this characterization, but they do not generally overlap in their ideological approaches or priorities, and they have in this area. And that is reassuring, is good to see. And this would also be a Republican author bill that we are supporting. And I hope that we will look for those opportunities to do that whenever possible to make sure we are a fair political practices commission whenever we can be. So for those reasons, I would like to see us send a letter of support of this bill, although I, of course, would like to hear your thoughts.
No, I agree. I think this is a pretty easy one. The commission, this is another idea that originated with the commission a couple of years back with our enforcement division. We recognize the challenges presented at the federal level with the FEC and the position it's in. This is an important issue, and so I think it's appropriate for us to support that. So this is, before I go any further though, let me pause. And is there any public comment on AB 319 before we move? Hearing and seeing none. At this time, I would then make a motion that we recommend to the full commission a support position on Assembly Bill 319.
A second.
Ms. Linker?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Moving on to Senate Bill 459. This is a bill by Senator Allen and relates to lobbying reports and advertisements. And the senator has asked for the commission to support, if amended, to include monthly reporting for all lobbying entities in Q3. So, Commissioner Baker, thoughts?
Yeah, and also for the purposes of disclosure, this isn't an ex parte conversation, but I was new to the Board of Common Cause when they began to look for this type of legislation. And as soon as I was appointed by Controller Yee, I recused myself from any conversations about it, and it actually happened. They were just beginning those conversations, so I didn't really engage in them as it were. But I know that there was some overlap here. I will say I'm torn on this one. There's a part of me that wants to look at it more. Of course, we've had an opportunity to do that. I certainly understand, and some of the provisions that Ms. McConnell mentioned, I think are very good ones. Having that extra disclosure in Q3 is good for transparency. I'm undecided on this one. I'm just going to be transparent with you. So I welcome your thoughts as well.
So one question I had for Ms. Nakano on this bill is, I will just say I have a concern with the adding disclaimer requirements to issue ads. From a legal standpoint, from a constitutional standpoint, from a policy standpoint, I can see the benefit of it, and I certainly support that because I think that it would assist with transparency. I do have a legal concern with that. And so my question is there currently a severability clause or some clarifying language in the bill where if somebody did challenge that provision, the other portions of the bill that I think the commission would naturally, I think, perhaps be inclined to support would remain in effect while the challenge to the disclaimer requirements went?
That's a good point, and the bill does not currently contain a severability clause, so that may be something that we can recommend to the author.
All right. Thank you. I appreciate that. I wonder, do you know from the author's office monthly reporting of lobbyists? It's one thing to do that in a non-election year. In an election year, that's a lot of reports that are having to be filed on behalf of entities around the state. And so I'm wondering, do we have any feedback from the author's office or from stakeholders who may have concerns that that's going to be an administrative burden or very costly for them to do?
I don't have information on that at the moment. The triggers are monetary, so it would only be based on their past activity, whether they would have to report monthly. And then at the most, if they had a quarter when they exceeded $45,000 or more in payments, they would have to report for the entire following year monthly, which could potentially go into a non-election year. So that's something I can get more information about, whether they've had any opposition or concerns about that portion.
Okay, I appreciate that. And then sort of sticking with the fiscal aspect of this, as we saw last election cycle, we do an ad watch program, which Ms. West helped put in place, and the Enforcement Division spends a substantial amount of time on the natural in election years, receiving complaints and processing and investigating things that come in through the ad watch. I can imagine that if every single year we had a regime in which all issue ads had to have disclaimers, that the amount of work, we would have a perpetual ad watch program, and it would expand to include these issue ads. And so my question is, from our standpoint, from a fiscal impact, have we looked into what that spike in our workload would look like and how many positions, if any, we would need to be able to handle that work if this passed?
We're still determining the fiscal impact and exactly how many positions this would take. I think that, depending on the amount of lobbying ads that are put out every year, it could impact FPPC's workload to a notable degree, at least.
All right. Sitting here today, do we have any idea how many issue ads, just in general? I mean, somebody must be tracking this, right? So how many issue ads are we looking at every year that would even be subject to the disclaimer requirement?
I don't have that data now. The author's office has put together background materials that I can check and report to the full commission about.
Okay. Have other states imposed similar disclaimer requirements on issue ads.
Not to my knowledge. That's something, again, I can check with the commission or author staff about.
Okay. All right. All right. I think those are all of my questions. Again, I think to echo what Commissioner Baker said, I'm somewhat torn because I think in spirit, in many of the provisions I agree with. I think they're worth supporting. I have some concerns, particularly around, I'll be honest, around the fiscal impact on our agency. I think that's a significant concern. So, Commissioner Baker, any
Well, you
further
asked all,
thoughts?
yes, all excellent questions you had, and I think we need to have more information. And frankly, we're at a stage in the legislative calendar where they're coming up on committee deadlines. There'll be people weighing in on these bills. It's going to get, if it gets out and onto the floor, you're going to hear a little bit more. I'd like to see this digested more, and before we get in there, and there'll certainly be opportunities for us to weigh in. Certainly on the good pieces, but there's enough that's been raised. I'm not prepared to have us take a position yet, and I think we should stick with that route.
Okay. All right. Fair enough.
Appreciating that the authors reached out. I mean, that is a good thing. Mr. Allen has a tradition of disclosure-related bills, which is a good one.
Right. And I think that we do appreciate that. That's right. And I think the tenor of our comments here today shouldn't be viewed as prejudging it one way or the other. It really is. I agree with Commissioner Baker. I just think we need a little bit more information. There are a number of questions about this. And again, not to beat a dead horse, but the fiscal impact on our agency, I think, is a significant concern. I am curious, though, do we have any public comment on Senate Bill 459, either by phone or digitally?
Hi, yes. Can you hear me?
Yes.
Hi, it's Trent Lang, California Clean Money Campaign. I was not intending to comment on this bill, but now that it's up, I shall. The California Clean Money Campaign is a strong supporter of SB 459. We think that the different lobbying provisions, the issue ad reporting provisions are very important. You raise a very important question about how many issue ads are there. And we, of course, had a bill a couple of years ago with Assemblymember Mullen that was going to go even further in terms of requiring disclosure on issue ads, which we're not bringing up now, but we may in the future. But one of the problems that we had was that we simply could not find out how many issue ads there actually were, how much spending there was on them of any nature, because there wasn't any kind of required reporting of them. So that, we think, is one of the very important features of this bill, is the requirement that over $5,000 of issue ads be reported. So we actually know who and what is being done, how many issue ads. We also do think that it's very important, the provision to require lobbyist firms and employers that spend over $15,000 in a month to have to report for those months, because those are obviously significant amounts of lobbying expenditures. And now there are many cases, especially in the last 3 months of the session, that people don't know who's actually making expenditures and on what. However, I would say that I would like to discourage the commission, if possible, from requesting or requiring that the author amend the bill to require monthly reporting for all lobbyist employer entities in the last 3 months of the session, no matter how much or how little they spend. It's one thing for lobbyist employers that are well-funded and spend over $15,000 a quarter to do the extra required monthly reporting. It's a very important public good because they are making the largest sorts of expenditures, and they also have the means and financial capability to do that sort of additional reporting. But for smaller nonprofit organizations that do have to file lobbying reports, having to file additional monthly lobbying reports, even when they're spending well less than $15,000, may even only be spending a few $1,000s, would be, we believe, a significant added burden on those nonprofits in the worst possible time for it to be in those last couple months of legislative session when they're fighting for their lives for legislation. So we would respectfully request that you not, even though California Clean Money Campaign, as you know, is all about increased disclosure, we think that in this particular case, that could be an undue additional burden with relatively small additional benefit, given the minor size of those any entities that spend less than $15,000 a month.
Thank you, Mr. Lang. Appreciate it. Any additional public comment on Senate Bill 459 before we move on? Hearing and seeing none. Commissioner Baker, I agree. I think this is one that's it's premature for us to act on. So Ms. Nakano, if you just communicate that respectfully to the author's office, that we have some continuing concerns and questions on this bill. That brings us to the last item that you identified, Ms. Nakano, and that's Assembly Bill 975. I know we are not being asked at this time to take a position one way or the other, but I just wanted to offer Commissioner Baker any questions or comments about Assembly Bill 975.
Thank you. I appreciate that. And I do have on this one, I don't think it is one that I would not be inclined to take a position. If we were, it would probably be to oppose it, which I don't know is going to be very constructive for us. But it has to do with the gift reporting time period in making it, in changing that. I having been in the position, I had a no gifts office rule where if you go to an event, what often happens is members go to an event in Sacramento, they have a choice of eating or drinking at the event, and if they do, they need to report it. They can also sign up on the I'm not eating or drinking, or just be in a situation where they need to be notified within a certain amount of time if they partook in something that could be a reportable gift, and from a lobbyist. I don't think it's appropriate to give more time to do that. I think the gift rule, it is a burden. It is, you got to really make sure you do it within 30 days. But those folks have staff, the organizations have staff to do it, and they have their own ethic where they can aggressively go out and get the information to make sure that they comply with their own rules. So that's the provision of this bill that concerned me. I think it actually leads to less timely transparency, and I just would not be inclined to support the bill for that reason. So that's the primary one that stuck out to me.
All right.
Certainly, I like the electronic filing parts, but the reality is, and we've talked about those, but the change to the gift time frame is too not good in my view to outweigh that consideration.
Yeah. So, Ms. Nakano, can you put a little more gloss on what is animating the author's proposed change on the time to reimburse or return the gift? Like, what is so challenging about the rule currently?
My understanding is that when the gift of admission is from a lobbyist, or lobbyist employer, lobbying firm, they don't report the valuation of the gift until after the end of the calendar quarter, which I believe, according to the author's office, does not give the person who attended the event enough time to report or to make reimbursement for that gift. And the valuation, as they explain it, can be more challenging than other kinds of gifts because it includes the cost of catering, other things that they partook in at the event. And I think it's divided by pro rata, depending on how many people attended the event. So there's more complicated valuation, according to the author's office. So that's the reason they're asking for this is when it's from a lobbyist, they don't report the amount until after the end of the calendar quarter. So they want that additional time after the end of the calendar quarter to figure out the value of this gift.
All right. I have a couple questions, and if you want to answer them, that's great. Or Mr. Bainbridge, put you on the spot for a couple questions. So my first question is, so I'm an elected official. I attend an event that a lobbyist is putting on. That lobbyist has they've set up catering, they've set up a venue, they've invited a certain number of guests. And so if everything goes according to plan, they know how much that costs. And if you break it down by the number of anticipated guests, you would at that time, before the event's even held, have an estimate, a good faith estimate, let's just say, of what the pro rata value to attend would be. Is that fair? I mean, is that accurate, Mr. Bainbridge?
Just one correction. We're talking about lobbyist employer putting on the event, right? Not the lobbyist. Okay. As far as I know, I don't organize these, but that is how you would generally calculate the value of the gift, would be the total cost divided by the number of people who attended. Right.
So that's our expectation of how you would value it. Now, is there anything that prevents the host of an event from telling the attendees, this is our estimated value based on our attendance list? Is there any prohibition that would prevent them from offering that information to the guests on the front end?
No, nothing would prohibit it.
And if they did that and an attendee acted accordingly based on that estimate, reported the receipt of the gift based on that estimate, would the attendee have an opportunity to, at some future date, amend or take, basically true it up, if they received at the end of the calendar quarter the actual, this was the value? Because the value may fluctuate a bit once you've accounted for guests who haven't shown up, or maybe more people show up and the value goes down. Is there a way to true up at the end so they could continue to report under the current timeline, but then simply amend later to true it up so that we continue to have the timeliness of the reporting of the information without folks feeling like they're, reporting something inaccurately?
Well, I think on this, one thing to keep in mind is it's less about reporting, because we're talking about gifts that are typically going to get reported once a year on the Form 700 Statement of Economic Interest. The 30 days is really the period, 30 days that they're interested in is the period to pay down or pay back the gift, so that it is then no longer considered a gift and it doesn't get reported at all. So I think then to answer your question, yes, they could always, if they reported it on an SEI, later found out that their amount was wrong, they could then amend the SEI to reflect that.
Right. Or, suppose you attend the event and you don't want it to be a gift, so you pay it back based on the estimated value. There could be some mechanism to true up at the end. If you've overpaid, presumably you would get a refund, or if you haven't paid enough, you would owe more. Is that a system that would be, from our standpoint, from our agency's standpoint, a workable thing to administer?
I don't know that I'm qualified to answer that question, whether it's workable to administer. You can always amend a statement if you get the amount wrong. If you return a certain amount and it ends up not being enough, I think you would then have an opportunity to return more money in order to, if you're attempting to, if you're making a good faith effort, whether that's technically a violation of the law or not, we usually look favorably on people that try to disclose whatever has happened honestly and fix whatever maybe mistake or difference there might have been in how much they paid down versus what the gift was ultimately valued at.
Right, and I think that's kind of where my mind is taking me here is, that's not going to be trigger an enforcement action. That wouldn't be a good use of our enforcement resources. To be chasing people down who are $5 short on the amount that they paid back based on the estimate they received. It's just a way to approach the problem maybe differently than what the author has proposed here. So I don't know, Commissioner Baker, you're probably in a really good position to tell me, no, Chair Madish, that's a horrible idea.
Well, no, I think it would make things complicated, but I also believe that, yes, the existing rule of 30 days to find out how much the gift was so that if you wanted to pay back to make sure you don't have a reportable gift, it is a quick time frame. It is a bit of a burden. You got to make sure that it comes back. But I guess I'm unsympathetic because it is one that they have I don't know that the system is broken in this respect. I mean, the legislative members have staff and their own ethic that they can make sure they are not waiting for the lobbyist employer to get back to them. They can chase them down. I've been in this situation where I've seen members who are making sure you don't wait to get the letter from them saying something was $10. You chase it down and get it. And the lobbyist employer, these are sophisticated actors who have the ability to comply with these rules. It's a pain because it's 30 days and it's a quick clock, but I think it's appropriate. And there are plenty of ways for members to get around it, which is appropriately so, and that is don't take a gift. It's hard to go to something to not eat or drink except a glass of water, but I'm unsympathetic. I also believe the way that this would be changed doesn't just apply to those situations that are more complex, like an event with a lot of people and a lot of catering rules, and you hope you get it right. It also applies to more simplistic transactions where somebody sits down and has a drink and dinner with someone, and you're trying to keep it below the amount so that you don't have a reportable gift. That's not very complicated. You should be able to find out within about a week or so, whatever the value of that was, or just pay for your own meal. So I'm a big mean person here on this one. I'm not as sympathetic because I don't think the system that's there is broken. Where it is a bit difficult is when someone makes a mistake, where the lobbyist employer gives either tardy information to the office so they were unable to avoid a gift, even through their best actions, or the member's office makes a mistake somehow. And I think those are rare and are very easily corrected. And it would be used against them, for example, if they're in a campaign someday, somebody to say, look, you took a gift from so-and-so and it was a donut, something very de minimis, but it'd be used against them. But I think they're rare and that this is appropriate.
Great. Thank you, Commissioner Baker. Let's go ahead and see, is there any public comment on this item? And we were talking again about Assembly Bill 975. Hearing and seeing none. Ms. Nakano, thank you for your update on this matter. You'll continue to track it for us and provide regular updates.
I should say thank you to the author, excuse me, Mr. Chair, for the electronic filing provisions, because I know we've been looking for folks to take those on, and sometimes we don't get to have them in clean standing bills. So appreciative for that issue in the legislation, of course.
Yes, I agree. Mr. Khanna, did you have any other bills that you were going to bring to our attention before we move on to item number 4?
Nope, that's it for me.
All right. Before we move on, though, can I ask you about Senate Bill 752 on campaign advertisements, and just give us an update on where that bill is and just in general what it would do.
That bill relates to electronic, changing the rules for advertisements relating to the Disclose Act. The bill is currently referred to a committee, but has not been set for hearing yet. Would you like a breakdown of what the bill does?
Well, my understanding, I've read the bill, I've read some background materials on the bill, and I guess what I'm really going to just ask you straight up is, have we done a fiscal impact study on that bill as well? Because I have significant concerns about the potential cost to our agency of administering that bill and the changes it's making to the disclaimer requirements.
It makes a number of changes to the content and form of disclaimers on advertisements. This could create additional questions for staff, advice letters, enforcement issues. The more details the requirements get, that can create or cause enforcement to spend more time trying to figure out whether the various ads comply with these very detailed requirements, such as spacing, colors, and related things. So this bill does change the form and content, or form and look of a lot of disclaimers, which could create additional costs for enforcement as well as advice.
All right, thank you. I think it'd be helpful for us to drill down a little bit on the fiscal impact on that particular bill. I think in spirit, this is one where I think it's a laudable goal to try and simplify, because I think what I take from this bill is the main point is to try and simplify and make clearer some of the most important information that's contained in the disclaimers that appear on electronic, social media type ads. So the spirit and the intent, sort of writ large, I think is important and something that I would support. I just think that it strikes me as very prescriptive in the way it's written, and that gives me pause in terms of what that's going to do to our workload. So maybe not this week unless you're able to get it done, but by next month, having some updated fiscal information would be helpful on that bill. Commissioner Baker, did you have anything on SB 752 that you wanted to comment on?
No, I do not. Thank you.
Thank you. Is there any public comment on SB 752 before we move on to item number 4?
Sure, yes. Trent Lang, California Clean Money Campaign. Of course, we are the sponsor of SB 752, working with Senator Allen. We are, of course, very eager to hear and look forward to hearing any feedback that the Commission has on costs, et cetera. You're absolutely right that the goal of the bill is to ensure the clarity and the transparency of the type of top funder information that the legislature passed when they passed the original AB 249 California Disclose Act. And I thank the former Assembly member for her help in that regard. What we have seen, the original California Disclose Act, of course, was very, very prescriptive in terms of the exact colors of backgrounds and font sizes, and requiring top funders to be listed on separate lines and things of that nature. I know that gave the Commission staff a little bit of heartbreak when we were working with the bill originally. The goal of this is, I think, in general, that level of prescriptiveness has worked very well in terms of the transparency, the clarity of people being able to see those top funders of $50,000 or more. What we've noticed in one area that we were not very prescriptive in the terms of the formatting, the disclosure on online ads. We have seen numerous abuses of the simple requirements that section had, that the disclosures just be easily readable by the average viewer. There have been many ads where they very much stretch the definition of easily readable. So the goal of this bill was to put in similar sorts of disclosure formats, prescriptive disclosure formats about backgrounds and font sizes and that nature to the original Disclose Act that the legislature passed, but to fix up some of these issues that we've seen in practice. So that was our goal. We certainly look forward to engaging with the Commission and staff in terms of any feedback you have in terms of things that might potentially be overly costly or any other issues that you might have. But that is the goal and the intent of the bill.
Great. Thank you, Mr. Lang. I did have a question for you, Mr. Lang, and that is, again, I want to reiterate, I think the goal and the intent and the spirit of this proposal is right on the policy side. I mean, as you know, we have the Digital Transparency Task Force. We are looking at how can we improve transparency on online and digital campaign advertisements. My question for you is, as we've heard time and time again, the technology and the means by which these types of advertisements, this digital advertising, is being done, they're constantly changing. And it, from a regulatory standpoint, can be very hard to quickly adopt rules, particularly when they're in statute, ensuring that those rules keep pace with the innovation and the delivery methods that are being used. And so for these types of disclaimers, has your group given any thought to setting a standard in statute, such as the one you just described, where it would be, let's just say, the advertisement must be easily readable by the average voter, and then allowing the commission through the regulatory process to set out the factors or the guidelines that would allow enforcement and legal to understand what is acceptable and what's not, so that we can more quickly and efficiently keep pace with the changing technologies by which these ads are delivered.
That's a great question. The challenge that we have seen in the past, before the Disclose Act was passed, and then even since it was passed in a couple of these areas like online ads, where we use terms like easily readable and clearly readable, is that they have always, in our experience and reports of people to us, they have always been severely abused. The definitions of easily readable to the average viewer, et cetera. I'm sure we could do a better job of putting in statute kind of what is meant by that to make it easier for the commission and maybe for some areas that the Disclose Act has not touched upon. Maybe that should be done, and be very happy to discuss those. But time after time after time, that sort of broad language that is not prescriptive has been abused, right? And the original disclosure formatting rules before the Disclose Act did have certain requirements, like minimal font sizes and types in some cases. And if it didn't even have those, then who knows what disclosures would have looked like even before the Disclose Act. So I think our goal is on some types of ads that are not changing very rapidly. Television ads aren't really particularly changing very rapidly. Print ads, radio ads, et cetera, and even online graphic ads have been basically the same for the last 2 decades, except that now they've started to add some visuals and more videos and things like that. So so that's why we very strongly believe that it's appropriate to put in some prescriptive things so that the disclosure formats are consistent and readable, easily readable across all different formats that are going to be consistent. But we certainly would be very open and to suggestions for how to provide flexibility when advertising formats change significantly, as we've seen, for instance, with since the Disclose Act passed, with the new use of video ads of different formats, which is one of the things that this bill attempts to help fix, amongst the other things.
Okay, great. Thank you, Mr. Lang. I appreciate the answer. Do you have any further public comment on SB 752? All right, hearing and seeing none. Commissioner Baker, any final thoughts on this one before we conclude our legislative report?
No, I think it's just fine. Thank you very much.
All right, thank you. Thank you, Ms. Nakano. Great job as always. All right, we'll go ahead and move to item number 4. This is a discussion of disclosure on electronic media ads. And we have Suki Brar, who's our Assistant General Counsel, and Torrin Lewis, Commission Counsel.
Good afternoon, Chair Matich and Commissioner Baker.
Good afternoon.
Nice to see you all. As you may recall, sorry, I'm hearing an echo in the background. Okay, sounds like that's better now. As you may recall, the Commission at its March meeting heard a presentation regarding a number of issues that staff has identified around the application of the disclosure requirements of the Act and regulations to blogs, news sites, social media platforms, and other types of online media. And so based on that discussion, staff has gone and written the memorandum that you have before you now, outlining some proposed regulatory changes, as well as one possible statutory change should the commission choose to go that route. And so what I can do, if it's helpful, is to briefly summarize broadly the areas of proposed regulatory changes. And then I'm happy to answer any further questions in further detail. So the first area of proposed change would be making some amendments to Regulation 18421.5. And this, as you'll recall, is the regulation commonly referred to as the blogger regulation. And so at present, this regulation does not require communications that don't qualify as advertisements to include in the heightened reporting requirements for committees who pay, say, social media influencers to post favorably about the committee, information about the poster's username or handle on their campaign forms. And so one proposed change would be to expand the heightened reporting requirements of Regulation 18421.5 to include more specific information in cases where these social media influencers, for example, are paid to post on behalf of a committee. Similarly, staff suggests that the commission could consider adopting a regulation or a regulatory change rather, requiring the title of an op-ed or article in the case of a writer who's paid by a committee similarly to write content regarding the committee or candidate or measure. And the third proposed change would be to harmonize the ad disclosure requirements and those of the regulation rather, and those of the act where there is overlap. So more specifically, Regulation 18421.5, it could be clarified in that regulation that where a communication is covered by that regulation, but would also meet the definition of an advertisement under the Act, the disclosure rules of the Disclose Act would still apply to that communication. So before moving on to the other proposed changes, I'll just pause there to see if Chair Matich and Commissioner Baker, you have any questions.
Thank you, Mr. Lewis. Commissioner Baker?
Thank you. And mine goes to, I think this applies both here and in where you're going to go further in the conversations. In a prior report to, I believe, the Law and Policy Committee and the Commission, you had exemplars, like examples of what this might look like. I think it'd be very helpful for the recommendations that you might be putting forward to show, okay, and here's how it would now be different. Have examples of the change. And that might, it's just good. I'm a visual person and I think other people might benefit from seeing that as well. And it also takes us through the very practical applications. So I know that's not something you have for today, but it would be helpful to see those before and after exemplars would be very helpful, particularly when you're referring to harmonizing the advertisement disclosure requirements. It plays it out a little bit better. That's just the overall comment that I have at this time. I'm interested in the rest of the report.
Thanks for that. Yeah, that's actually something we discussed, so it's very helpful feedback.
All right, go ahead and continue, Mr. Lewis.
Okay, so the next area of proposed regulatory changes that we envisioned would be some new regulations regarding disclosure required on electronic advertisements. And so specifically, new regulations specifying that, well, actually, I'll back up. I'll back up to describe in the current situation, the legal division has informally advised that where an influencer is paid by a committee to post on social media, that the post should tag the committee so that voters can actually link back to the committee's profile or landing page and see the full disclosure. But we actually recommend codifying this advice in a regulation. And in addition, similarly, on video advertisements, which are posted on social media that qualify as ads, there are some questions around whether the disclaimer needs to be only on the landing page of the committee or the video itself. And again, we've advised informally that advertisements in the form of videos, no matter where they appear, have to follow the special video rules under the Act, including social media. So that's a second area where we recommend codifying the legal division's informal advice. And finally, there's some room to clarify in the case of individual website posts or blog posts that meet the Act's definition of advertisement, where exactly the disclosure statement should be located. And so we recommend requiring that the disclosure for such communication should be located either at the top or the bottom of the individual post, rather than, as some people might assume, the top or the bottom of every page of the blog or website. So those are, I believe it was 3 recommended changes in addition to the amendments to 18421.5 that we recommend. And finally, if the commission chooses to go the route of a statutory amendment, similar to the discussion about where disclosure should be required, the Act actually provides that in the case of social media advertisements, the required disclosure should only be required on the landing page or profile page. And so we recommend, or rather, should the commission choose to go this route, one option would be to amend, I believe it's 84504.3 H1 to change the language saying that such a disclosure shall not be required on each individual post or communication.
All right. Can you clarify something for me, Mr. Lewis? I'm on page 2 of your memo, and can you just sort of flesh out a little bit more under the heading New Regulations Specifying Advertising Disclosures on Electronic Advertisements? On page 2, there's the second full paragraph begins with as mentioned above, and then the third paragraph similarly. Can you just kind of walk me through, again, the difference between what staff is talking about in those 2 paragraphs? I think I'm conflating them in my mind, so can you help explain that one more time for me?
Sure, let me just reread this to make sure I'm on the same page, literally.
Is it that one is social media posts and the other is more what can be almost like articles from a website or blog? Is that the distinguishing feature between the 2 paragraphs?
So when you say the 2 paragraphs, Mr. Chairman, are you talking about The second paragraph down from the heading on page 2, as mentioned above, the Act does not explicitly address.
Correct. So that situation, you're referencing the third-party influencers paid by the committee, right? And the point there is if the committee did it themselves, there'd be disclosure, but when the influencer does it, at their being paid to do it, our advice has been there's no legal requirement, but we advise them to tag it. And then the next paragraph, I'm just trying to understand is what those two different examples look like in practical application, because in one example, in the first paragraph we're talking about, the legal division has advised that there should be a tag. We should tag the committee in the influencer's post. But in the next paragraph you're talking about, in that situation, the advice from legal has been you could satisfy both the reg and the act by including an ad paid for disclosure with each individual blog post. So it seems like they're talking about the same thing, but we're advising two different things. So I'm just trying to get it square in my head.
Yes, okay, so I'll start with 18421.5. So that regulation requires heightened reporting in the case of a third party being paid by a committee to post favorable content on the internet related to the committee. So that could be social media, it could be a blog, but somewhat confusingly, that requirement may be met under the current regulation by instead ensuring that the post itself has, I'm trying to find the right term to use without the regulation in front of me, has a disclosure of some sort on it to indicate to the viewer that that poster was paid to post that content. But where it becomes confusing is that that requirement is not harmonized with the advertising disclosure requirements of the Act. So where there is overlap, we think we could clarify essentially that the Disclose Act requirements either supersede those or that both are required. That would be up to the commission, but that's one area of overlap of the two different rules. And the second aspect of this is that where the committee itself posts on social media or its website, we can further clarify where the disclosure requirement must appear. I shouldn't say physically, maybe in the realm of cyberspace, but must it be at the top or bottom of every post, or must it be only at the top of or bottom of the landing or profile page of the committee that's making the communication? So those, I think, are the multiple layers. I'm not sure if I've garbled that further or if that helps.
I think it helps.
Okay.
So let me just, for the benefit of sort of myself and maybe others, so if we have a situation in which a committee has paid a blogger to post favorable content on the blogger's site about the committee's favored candidate, right? So we know that under the regulation, that payment currently would be, and this is regulation 18421.5, the payment from the committee to the blogger would be reported on the back end, on the campaign reports, right? And so part of what staff is saying is we could expand the detail required in those reports to make it easier to know who that, so the public could see more easily who the blogger was that was receiving the payment. And then I guess in theory, you could trace it back to their site and then know that their content was paid for by the committee. That's one approach, right? Amplifying the disclosure on the reports. The second piece of it, and the one we were just talking about, is what if anything do people who see the blog post see when they're accessing the blog post? And one bit of advice from legal is the blogger could tag the committee, which would then give an easy way, I guess, for the reader to click to the committee and find out the information about the committee. But I take it under that circumstance, there would be nothing necessarily in the blog post itself that would be disclosing to the reader that this was a paid political ad. They would have to intuit that by the existence of the link and the tag to the committee. Is that right?
That's correct.
Okay. But then continuing on, we have also advised that in that same circumstance, if the blogger added a statement that says ad paid for by and identified the committee that had paid the blogger to make the post, that is another way that the act and the regulation could be satisfied.
That's correct. And specifically, the committee could satisfy the regulations reporting requirement through that additional disclosure by the blogger or the social media poster.
Okay. Well, so just I want to put a fine point on that. Now you're talking about the committee. The committee could satisfy both the reg and the act by having the blogger include the ad paid for by. Does that mean that the committee wouldn't have to disclose the payment on their report then?
No, sorry. So I should be more specific. So I should speak more holistically as you did. The committee who is paying for the favorable communication could satisfy all the requirements of 18421.5 by alternatively making sure that the disclosure appears on the post. But any, as mentioned, if that communication rose to meet the definition of an advertisement under the Act, of course, further disclosure would apply. And generally speaking, expenditures have to be reported regardless of 18421.5 as well.
Matt, this is Suki. Maybe I can add a little bit that might help to understand this situation.
Yes.
The first paragraph that is talking about tagging, that's specific to social media because there the disclosures have to be on the landing page of the committee when the ad's posted on social media. And then the next paragraph that is talking about websites, that's talking about websites specifically. And if it's not social media, but more of a website format, we don't have clear guidance on where exactly the disclosure should be placed. And so we wanted to do a regulation to clarify that it should be at close to that portion of the blog post. If there's multiple posts on that website for different things, that the disclosure should go close to where the post is that is an ad, rather than at the top or bottom of every accessible page of the website, which is what is normally required for a website in general that's paid for by a committee.
All right, I think that's helpful. So now let me ask you this question. So do we have the option by regulation to require each blog post by somebody who's being paid to post it by a committee to include an ad paid for by disclosure statement for both content that's posted on a website and content that is posted on social media? Because that's one of my concerns, is that if the whole point is we're trying to get disclosure on the influencer's content, having it different in two different locations when it could be the same content, just published two different places, seems inherently confusing to me. So I just want to know, could we do just the ad paid for also on social media?
So I can see how that's confusing. I think on social media, we can't do the ad paid for because the statute is restricting us and saying that the disclosure should only be required on the landing page of the committee when it's on social media. So we've tried to at least just require the tag without more to the committee's page so that people can at least link to the disclosures, because the intent there is that people are supposed to be going to the committee's page to find the disclosures for who's paying for this profile's ads. And so we feel like the most we can do is require at least a tag back to that page from a social media influencer's post, because the tag will lead you to the disclosures, and we're restricted from requiring the disclosures elsewhere in that circumstance.
Okay, Commissioner Baker.
Thank you. And I'm right there with you, Mr. Chair, on trying to figure these all out and where they are, which I think emphasizes how helpful it is to have a visual for those of us who are visual learners. But I do want to say, and I think I mentioned this at the last commission meeting, the tagging, the extent to which we're relying on just tagging the blogger tagging in their post. Let's say it's an influencer and says, Chair Manage is a great candidate for XYZ, and tag Chair Manage's Twitter account. That is ambiguous, I think, to the recipient, because you tag people because you want folks to go follow them. You just tag them so that there's lots of other reasons for tagging, and I don't think it's clear. And then when you go to that landing page, it might say this landing page is paid for by Chair Manage. Sorry to be singling you out, Mr. Chair, but it is an ambiguous message. And I will continue to have that concern to the extent we're going to be relying on tagging. I don't think it's accomplishing that. It's not giving us clarification. So I hope we won't rely on that. And then second sort of feedback I have is that on the candidates, I'm going to say committee or candidates disclosure forms, I'm finding myself very supportive of enhancing what's on there so that they are going to be saying whether it's this article for this influencer is what I paid for. I'm finding that a good type of transparency to have, regardless of what disclosures are going to be on a post on social media or on the blog itself. And I think my final sort of suggestion is that we explore if the blogger has anything on their page that says some of the content on here might be paid for by someone else. I might be paid to say what I'm telling you. That could get constitutionally very difficult, and that might be too ambiguous, but what responsibilities we're going to put on the blogger as opposed to the committee, I think we have to have a conversation about that. So these are the areas that I'm finding as I'm looking at this are either making it more blurry or where we need to focus. But if we had visuals, it would make it very easy to distinguish the different scenarios we're looking at.
I agree with you that the tag is not the best way to do it. I feel like that's as far as we can go via regulation. It's better than nothing. And that's why we also have that statutory proposal in the memo at the very end to do that instead, to do exactly what you're saying, to put more disclosure on the post.
Can I ask and by the way, I agree with Commissioner Baker and everything that she said, although I do understand, in fairness to staff, who I think is doing the best they can, given the statute, that the tag, I don't hear our staff saying the tag is the optimal policy. I think what we're hearing, they feel like that's the best they can do under the existing law. And so something's better than nothing, I think, at the end of the day. Although I do now want to ask my question about that, because that is premised on a reading of section 84504.3 H1 and how it says that the committee shall not be required to include, and you have a bracket and it says the required disclosure on each individual post, comment, or similar communication. And my question for you is, some political ads that I've seen on social media, at the top, they just have a statement that says paid political advertisement. So, which I understand to not be, in the words in the memo, the required disclosure that's being referenced by section 84504.3. So I guess my first question is, am I incorrect about that? Would you agree that something as simple as just paid political advertisement doesn't fall within the scope of the prohibition in 84504.3?
That's not something that's required specifically under the Act, so I'm not sure what they were following. It could be the social media platform puts that there or requires that. That's not the wording that the Act requires.
Right. No, that is exactly right, and that's my point, which is if it's not the required disclosure that's being referenced by that section, that it's not subject to the prohibition in the section, which means that instead of just tagging, I'm wondering out loud whether staff could take a look and see whether they think we have the regulatory authority to require a simple 3-word statement of paid political ad on the blog post, and then just simply link to the committee landing page from that statement, which seems to me to both clearly communicate to the public that this is paid political content and also gets them to the more specific information, as opposed to just tagging, for example, where it is, for the reasons Commissioner Baker pointed out, kind of ambiguous why you're tagging the committee.
Okay, we can look into that too. Yeah, I hadn't thought of putting something completely different.
All right, thank you. Commissioner Baker?
What I wonder about that, I think that's very creative, though, is by sending someone to a landing page, even with, paid political advertisement, you click here and you go somewhere else, unless the somewhere else is, I have paid for this, or someone has paid me to say these things. Is the landing page like the candidate's website? That somewhere at the bottom or in all the appropriate places says paid for by, Catherine Baker for whatever, 2020, whatever. It doesn't, it could have their contribution page. It could have their volunteer here page. So I'm wondering what that landing page is, even by saying paid political advertisement, unless the landing page is more explicit, we're really just encouraging influencers to push people to that candidate's website for even more information, which is kind of a value. I don't have a problem with that, I think, but if it doesn't, I'm trying to get what landing page information we're now potentially considering requiring, unless it's an actual, I paid for this.
Yeah, well, that's a good question. Either Mr. Lewis or Ms. Brar, if hypothetically, I know we don't have a visual, but like, what do we see when we go in the circumstances where we are linking to the committee's landing page? What is the information that the voters are seeing there?
They're seeing, if it falls under Act and requires disclosure, they're seeing ad paid for by committee name, top contributors, and whether or not it was an independent expenditure that was paid for by a candidate.
I see. Okay. So not just their website that has disclosures on it. It's a particular, almost like page within their website that has their disclosures about that particular ad. Not about that particular.
The ad links, the ad will link to that page. That page won't tell specifically, which ads.
Ooh, that's tough.
All right, Commissioner Baker, did you have additional questions or comments?
No, I would probably be repeating the same few things I've already said a few times, but I appreciate this is a complicated issue, that the goal is transparency. And of course, with our digital task force, we're really desperately trying to accomplish that in a thoughtful and data-based way, where the person who's receiving the disclosure gets the information in a clear way. Very tricky. And I guess at this point, I would need to see where now will we be? What feedback or decisions do you need from us today to take what next steps that you propose?
I think the first. Oh, sure. I'll defer to Suki if she has something as well.
Go ahead, Torn.
Okay, so the first question that comes to mind for me is, we specifically did not look into, in the drafting of this memo and proposed regulatory changes, requiring additional disclosure language on the posts of third parties who were paid by a committee or a candidate. We looked into options for where existing disclosures should be required in that sort of arrangement, based on interpretations of the existing statute and regs. But it sounds like, Mr. Chair and Commissioner Baker, you're interested in having us look further into the particulars of requiring disclosure language on the post of, say, an influencer who is paid by a committee to post favorable content.
Well, since I opened up the can of worms, let me just articulate what it is I was thinking. It hadn't occurred to me, Mr. Lewis, until we were sitting here right now, and I really was kind of just parsing that statutory language. That currently we see this as kind of a binary choice, if you will, between at least when there is a post on social media by a paid influencer, it's either you can tag the committee, right? Or we have to go and get a statutory change in order to get the full disclosure that is currently located in the Disclose Act. And I think, and so my thoughts started to go towards, well, is there a third option here that we haven't explored, which is, I understand we can't have under the current act, we could not use the full disclosure in each individual blog post. And so is there an alternative? Could we simply identify it as paid political ad and then link back to the landing page? So it remedies, or I think it would address some of the concerns Commissioner Baker referred to about the tagging not being clear enough, but also would not be as burdensome as requiring the full disclosure on every single blog post. So I'm trying to kind of find the middle ground. Mr. Bainbridge is grabbing the microphone.
Yeah, I'll add this in on this issue. So one thing to keep in mind is rule for blogs and the rule for social media are different. We have more room under Blogger to dictate where something should be. The problem with trying to add something for social media is under that 84504.3 H1. It says the advertising disclosure shall only be required to include the disclosures required, and then it describes what the disclosure would be. So that language is somewhat unique to the Disclose Act, and so to me, the only way to read that is this is the only disclosure that will be required. So I think that limits our ability to then add another disclosure on it because the statute's so definitive in this one subdivision.
So my idea isn't a good one.
It's a great idea for legislation, but I think our hands are tied for regulation.
All right, that's a good answer to you. All right, thank you, Mr. Bainbridge. All right, Mr. Lewis or Ms. Barr, I think the question to you guys then was, do you need specific feedback or guidance on any of these issues? I think we can take my idea off the table based on what Mr. Bainbridge just told us.
I'll speak here. I think we've gotten some guidance. We actually have draft language that we're about 98% done with. We've been rushing to get it ready. So we plan to distribute that this afternoon. So I think that will help conceptualize some of these ideas, at least as to part of what we're proposing. You guys will have language for Thursday, and we'll get it out this afternoon. And so I think that'll help with understanding exactly what we're looking for. We were mostly today presenting the memo just to get input and see if the commission thought we were on the right track with what we're proposing. So you will get that language later, and we'll have that on the agenda, posted on the agenda for the commission meeting on Thursday.
Okay, that's great. All right, Commissioner Baker?
Will it be possible, and I know that it would be a fair amount of work, so it may not be possible for Thursday, the extent to which the report will include that language, you can do visuals? Like, here's an example of what we're talking about. If that is at all possible for Thursday, great. If the time frame is not reasonable, I will be grateful for it whenever it's there. I think it's helpful. Frankly, it also might have made it more clear when we were talking about the difference between social media posts and a blog or website post. You know, I'm thinking of lots of blogs that have articles and things, but they're not Twitter or Instagram or Facebook for us old people. And that alone is a helpful distinction to understand in the law.
Yeah, we'll work on visual aids. We've got the ones from the presentation last month, and we'll look and see what else maybe we can add. Maybe just 2 columns. One, here's the current requirement to satisfy or as an alternative to the enhanced campaign reporting versus what is the advertising disclosure required by the Disclose Act. So at the very least, we can have the slides we used last time and maybe have a little pointer and show you what we're talking about in terms of locations and why it's an issue and how you tag someone and that sort of thing. And then we'll also flesh out how the Disclose Act requirements can be different from what is in the Blogger Reg, which the reason it's not consistent is just because the Blogger Reg was adopted back in 2012 and the Disclose Act was passed just a couple years ago. So it's just a long overdue update to the Blogger Reg to make sure it's consistent with what the Disclose Act requires.
Very helpful. Thank you very much.
All right. Thank you, Mr. Lewis. Thank you, Ms. Brar. Thank you, Mr. Bainbridge. Looking forward to your report later in the week and the visuals. Before we leave this item, though, is there any public comment on item number 4 on our agenda today?
Hi, yes, Trent Lang, California Clean Money Campaign. This has been a fascinating discussion. I'm really glad that you guys are digging so deeply into some of these issues, not all of which were contemplated during a passage of the Disclose Act. I see the limitations that you have in terms of what you can do with regulations given the current statute. I'll just say on a couple quick things. I absolutely agree with some of the decisions that you've made, such as that the disclaimers on video ads should apply no matter where they are on online advertisements on the internet. That was definitely part of the intent of the original Disclose Act, so that is really good. One of the interesting things that you guys are discussing, the difference, some of which we had not contemplated in the original Disclose Act or even in the follow-up Social Media Disclose Act, was the difference between advertisements where the committee is paying Facebook to place and circulate an ad. That was thoroughly contemplated, and that was the intent of AB 2188 by Assemblymember Mullen, the Social Media Disclose Act, to require ads placed on social media sites like Facebook and Twitter, et cetera, to have to disclose their funders, versus, as you're describing, paying influencers that post on social media versus their blog posts. The Social Media Disclose Act's intent was that any ad that was paid for, paying money to the social media company, the social media company would have to put in a paid for by at the top of those paid advertisements with the normal Disclose Act required disclosure information of top 3 funders. I am not convinced that they are following the letter of that law quite yet. So that's something we need to investigate. But it was not meant for, designed for paying influencer on social media posts, which should be covered. You guys are absolutely right that the commission is actually right that needs to be covered. The though I'm happy to say that I drafted most of Section 84504.3 with the input from many people, including the commission. The Section H1 was a little bit unique to the Disclose Act because that was written by stakeholders to limit disclosures in particular manners that were actually reasonable in what was being contemplated, which was if a committee has a committee website that individual posts on that committee website do not have to be tagged with disclosure information as long as the committee page has the required disclosure information. That still seems reasonable to me, but it does not address the issue that you are describing, where the social media posts are not appearing on committee websites and you're trying to get to that web tagging. I would say that we would be very open to talking with you and working with you on potential statutory changes to give you the sorts of power that you'd like to do in our current bill, SB 752, or I should say recommending to Senator Allen that be be included if something reasonable can be done to kind of give the sorts of statutory abilities that it sounds like you might like to have, and that sound to me would be very reasonable and appropriate for extending to these sorts of issues. So would be very happy to discuss that with the commission further going forward if you are interested.
Thank you, Mr. Lang. I appreciate your comments and appreciate your offer to work with you on SB 752. I imagine Ms. Nakano will be reaching out shortly to get that dialogue going. So appreciate that.
Great.
All right. Commissioner Baker, anything further on item number 4?
No, thank you.
Thank you. All right, moving to our last item. This is a discussion of items for next month's committee meeting. So this is an opportunity for committee members to just identify things that may be on their mind of interest for future meetings. I know one item we're sure to have back is the legislative report from Ms. Nakano. So we look forward to that. I can envision that perhaps we want to continue having a dialogue on the electronic media advertisements and that project at next month's meeting as well, depending on how far staff gets with their work on the regs and the feedback we give later in the week as a full commission. And Commissioner Baker, I know you had previously expressed an interest in having behested payments come back. I think that timing is about right to come back with a progress report from staff, because we do have that on our regulatory calendar for later in the year. So by my count, that's legislation, electronic media, and behested payments. Did you have anything further you wanted to add to our agenda for next month?
Well, thank you. I see that as well. And you read my mind regarding behested payments, because I know I've been doing that drumbeat since joining the commission. My understanding that is July is currently the scheduled time for possibly pre-notice discussion. And I think it would be very helpful if, when we have our behested payments discussion, we could do a conversation in May that includes, just helps us drill down so that we can have a little bit more focus on it. And both with respect to how nonprofits are used and the nonprofits that members may, or elected officials may be connected to through staff or family members or consultants, as well as the disclosure components of this. So I really hope that we can have that for sure on the May calendar in advance and not wait until July.
Great.
And any other further guidance that's helpful to help the staff use their time well on that, I welcome.
So, Mr. Bainbridge, does that comport with your schedule and staff's schedule to have them come back with kind of an update of where they're at on behested payments and maybe a review of some of the things we've looked at in the past?
Yeah, so we're not talking about the language. That can wait till maybe July. We're more talking about what are the bigger issues that we anticipate will be included in the reg package that we'll be presenting in July. Is that the gist of what you're looking for?
I think it'd be useful to have a conversation about concepts and issues that we want to focus on, so that staff can then drill down on those specific areas of interest. Is that, Commissioner Baker?
Yes, that is said much more articulately than I was getting at, which is so that come July, you've had the benefit of feedback from us already, so that July reflects that.
Correct.
Yes.
Yep. Great. All right. Anything else that you wanted to sort of tee up for our May meeting, Commissioner Baker?
No, thank you. That's a good, hearty agenda.
I agree. I agree. All right. Well, at this point, we have come to the end of our agenda. Commissioner Baker, with your indulgence, I would move that we would adjourn.
Yep, second.
All right. Thank you, and I'll see you Thursday.
Thank you. We'll see you then. And thanks to the staff.